A big debate is underway after the Supreme Court's judgment on Monday as regards a 2012 rape and murder case. All three accused in the Chhawla rape case were acquitted by the Supreme Court. Like I said, it's hard to wrap our head around this verdict. The trial court had sentenced all three accused to death. The Delhi High Court had upheld that sentence, but the Supreme Court was not satisfied. The prosecution, they said, could not prove beyond reasonable doubt that the accused were guilty. The victim's family has expressed their disappointment at the verdict, saying they've lost faith in the judiciary.
लोअर कोर्ट की फांसी का ऑर्डर होने के बाद, हाई कोर्ट का फांसी का ऑर्डर होने के बाद 7 साल लगभग सुप्रीम कोर्ट में हो गए। उसमें बहुत उम्मीद रखी थी हमने कि हमें न्याय मिलेगा, लेकिन सुप्रीम कोर्ट के जो जज हैं उन्होंने इस ऑर्डर को अपने घर का ऑर्डर बना के बिक गए हो और गरीब को साथ नहीं दिया। उन्होंने मुलजिमों का साथ दिया है। आगे क्राइम होते रहेंगे, बढ़ते रहेंगे। इस तरह मुलजिमों को फ्री कर दिया जाएगा। तो बीत बहुत कुछ रही है, लेकिन कर कुछ नहीं सकता, क्योंकि जब मैं 12 साल से अब तक कुछ नहीं कर पाया तो अब क्या कर पाऊंगा।
The verdict has now become political as well. The Congress is accusing the BJP government of serious lapses during the investigation. They forget that the case happened when the Congress party was in power.
The attitude and candor of the Bharatiya Janata Party and its government when it comes to women's safety has always been lackluster and compromising. Whether it was in Kathua rape case, whether it was in Hathras, whether it was in Unnao, and now in Kiran Negi rape and murder case, the attitude of the BJP government is the same. We appeal on behalf of the entire country and its daughters. BJP government should wake up and should file a review in the Supreme Court. Should put up its best lawyers before the Supreme Court. Should replace evidence and facts before the Supreme Court so that the verdict is reviewed.
I think the message is very sad. And it's not just me. I've got so many calls since morning, and everybody is feeling the pain of this family. And that people who did this crime, even if they were not these people, then who are they? I mean, the entire system has failed this 19-year-old and her family. 2 courts have already ruled that these people are the rapists, they are the murderers, and they have ordered the death penalty. So what is it where did the system falter? What has happened? One has to obviously file a review petition, and the Delhi Commission for Women, we are taking a legal opinion. What should be the way of it? What should be the method of it? And I'm also going to be meeting the family.
Same investigation which was presented to the lower court and high court was acceptable, and also on the basis of evidence and investigation that the court gave them the capital punishment. But then court is again raising the issue, the question. That means somewhere police has done a very shoddy job. Or, I mean, police should be held responsible. Whatever the Supreme Court should review it. Whatever is the situation, they should review it. I think review petition should be there. They should do suo motu.
Joining me now to discuss this verdict is Sonia Mathur, who's a senior advocate, and more importantly, she was the amicus curiae in the case. Sonia Mathur, thank you very much for your time here on Mirror Now. As amicus curiae, how do you feel about the Supreme Court judgment? Because everyone in this country seems to have an opinion on it.
See, let me get one fact clear first, that I appeared in this case as an amicus who's called a friend of the court. So I had no other interest in the case, no commercial interest in the case, except for placing the entire evidence as it was before the court. Then it was up to the court to see whether the submissions which were made by me or wherever there were lapses in the investigation or in the prosecution, how they would impact the case. So I had only placed the entire evidence which was there as it was. And this was, unlike Nirbhaya, it was not a case of an eyewitness. It was a case of circumstantial evidence, where the scrutiny is a completely different approach that the court would have. for the scrutiny of the evidence. So my heart goes out to the girl. My heart goes out to the family. It was a very, very heinous crime which has happened. Nobody deserves that. But then at the same time, the evidence has to be taken as it is. And I think the Supreme Court has very clearly recorded that there is no scope for emotions in criminal cases. They have to only go by the evidence. So they have analyzed the evidence and they have taken a decision, regardless of the emotional aspect.
Now, the question that is being asked is, and that is being raised is, how two courts can have two completely different points of views and different judgments based on the same set of evidence.
See, that's the criminal justice delivery system. There is hierarchy and there are different tiers. These are the built-in checks and balances. Every court examines the evidence independently. And this was not a case which was decided in a hurried manner or anything of that sort. It continued for almost 2 weeks. And morning to evening, they analyzed, they saw the entire evidence as it was. State was represented very well. The complainants' counsel was there all through. So it was not that, it's kind of a whims or fancies or a call which is not really a well-considered decision taken. They had analyzed the evidence. And this is our system. At every level, the evidence is examined. If we say that one court cannot take a view different than the other court, then the justice delivery system itself will fail, no?
When you read the comments and the remarks that have been made by the Supreme Court, it's clear that the Supreme Court is anguished with the way the prosecution has behaved. As someone who's been, who has seen this trial very closely, I want to ask you to help us understand where all the prosecution failed. The court has said that the convicts were deprived of their right to a free trial.
One is, of course, that there was the genesis of the whole case is abduction, the kidnapping of the girl by the accused persons. So there was no identification there. Nobody identified the car. Nobody identified the accused. Even the car registration number was not there, not available to the police. And then so far as the trial part is concerned, so that is one aspect. And then if we talk about the recoveries which were made, even there is no consistent evidence with regard to the recoveries which were made. Haryana police gave one version, Delhi police gave one version. There were discrepancies in the evidences of different witnesses. Even private witnesses also had given a slightly contrary deposition testimony. And so far as the DNA is concerned, the DNA report was, there was no allele table, there were no working sheets, there were no statistics as to how a particular conclusion has been arrived at. Because this was a case of mixed DNA, so therefore it became all the more important that the trial court could have called for the record, and at the stage of trial, this discrepancy could have been sorted out. The court could have examined the records to see whether the examination has been correctly done or no. And the car from where the samples were picked up, that car was on road for 4 days. And the owner of the car had also said that he had washed the car, he had used the car with his family. So therefore, and the car was not even in a sealed condition. It was unlocked when it was examined by the experts. And even the samples which was collected were sent to the CFSL after a gap of 10 days. So therefore, the court considered that there was a possibility of there being tampering with the evidence. And there are various other, small instances, but small but significant, which were placed before the court during a very, very prolonged hearing.
Ma'am, is the court saying that the wrong guys were arrested?
there is a difference when it comes to, so far as the criminal jurisprudence is concerned, the state has to prove its case, the prosecution has to prove his case beyond reasonable doubt. There should not be an iota of doubt in the culpability. But so far as the defense is concerned, they have to only create a reasonable doubt. So therefore, a doubt has been created. It's not a case of clear acquittal. The court has given them a benefit of doubt. It was just a doubt which has been considered sufficient. They didn't have to record a finding whether they are the guilty persons or they're not the guilty person. The defense has done its job by only creating a doubt. And they have said so. The judges have recorded this in the order that prosecution has failed to prove its case beyond reasonable doubt.
There are many people like Swati Maliwal who are saying we are taking a legal opinion and that there should be a re-investigation or a re-probe in this case. It's been what? It's been 10 years since the incident happened. The prosecution has been pretty shoddy. That's what the court has said. Is a re-investigation even possible, practically speaking?
See, now, so far as that part is concerned, I would leave it to the wisdom of the complainant and their legal team and also the state. But if you ask my personal opinion, then it's been 10 years since that incident happened. So I am really not in a position to say that after 10 years, how a re-investigation, etc., would really help.
Sonia Mathur, thank you very much for speaking to us. That was Sonia Mathur speaking to Mirror Now on why exactly is it that the Supreme Court has let go of the 3 convicts who were accused in a rape case, in a rape and murder case that dates back to 2012. We leave it there, ma'am. Thank you very much for joining us.